On the record in the matter of the people of the state of Michigan versus Risha Turner, file number 22-02501. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Riley on behalf of Ms. Turner.
Ms. Turner, how are you? Hi, today. I'm good, thank you. Today's the date and the time that was set for jury trial. I have an advice and rights of plea information sheet. And so she's pleading to the charge.
Yes, well, to amended charge.
Yes, Your Honor.
We don't do that here. We had ample time to negotiate. This case has been open since 2022. Offers were extended. I made it clear the offers and the time to extend offers expire at the time of the final pretrial. That's why we have a final pretrial.
Your Honor, it would be a plea to the offer that was made of malicious destruction of building 200 or less, no contest, Your Honor, with restitution to be determined.
Okay, you can be seated. Back on the record in the matter of the people of the state of Michigan versus Risha Turner. File number 22-02501, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Rowley on behalf of Ms. Turner.
Okay, today was the date and time set for jury trial, and Ms. Turner, my understanding is that there was an offer that was extended to you back at a final pre-trial that you now want to avail yourself of. I'm not going to hold that against you. The attorneys in this courtroom, if they weren't aware, they're going to be aware after today that my policy is that offers need to be extended and offers expire at the time of final pre-trial. And your offer, which you were advised of at the time that the offer was extended, it would expire at the time of the final pre-trial. And I held an additional final pre-trial. So you had two. And today was the date and time that was set aside for your trial. You had a priority date, meaning your date was older than some of my other cases. So I specifically expected yours to run today, only to find out that you want to avail yourself of an offer that was extended to you a few months ago, meaning I could have put somebody else in a trial date today, and I cannot. And so, because you weren't properly advised that that was not, no longer an option, I'm not going to hold that against you. But I think the prosecutor and the defense attorneys are well aware, and my staff, that we don't accept offers after final pretrial. The negotiations take place and not on the morning of trial, okay? Okay, thank you. And so the offer is what, Mr. Brodowitz?
It would be to plead to an added count 2 of malicious destruction of building $200 or less with plead no contest to an added count 2 malicious destruction of building $200 or less with restitution to be determined, Your Honor.
What's the purpose of the no contest?
The lack of memory due to intoxication.
Do you have a police sheet?
Yes, Your Honor. And apologies, there would also be a killer group or no upfront jail, Your
Do
Honor.
you have a police report?
Yes, Your Honor. Permission to approach, Your Honor.
Okay, so the offer is for you to plead no contest to an added count 2 malicious destruction of a building, $200 or less, and to pay restitution. That's what the offer you want to accept? Yes. What's the restitution amount?
That is yet to be determined, Your Honor. We would ask that this be set for restitution here.
We have witnesses here.
Yes, Your Honor.
Who's your witness? Are they present?
They are in one of the conference rooms outside, Your Honor, but yes, they are here.
Can you get the witness, please?
Which one? Oh, yeah.
Okay, so ma'am, you have the following rights if you want to avail yourself of this offer. But let me first have you raise your right hand. I don't remember swearing you, and I'll do it again if I did. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Okay, and so you understand, ma'am, in this matter, you have the right to proceed to jury trial? Yes? Yes. Okay, you have the right at the time of trial to the presumption of innocence. So you're innocent until proven guilty. Do you understand that? You have the right to require the prosecution prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You understand that? Yes, I do. You have the right to remain silent at your trial and not have silence be used against you. You have the right to confront in court and cross-examine any other witnesses that the prosecution intends to call. And you have the right to call your own witnesses or present evidence that you believe further a defense to the charge being brought against you. Do you understand that? Yes. Are you willing to give up each of those rights today in order to enter a no contest plea? Anybody threatening you to get you to enter a no contest plea today?
No.
Anybody promising you anything if you waive your rights and enter a no contest plea?
No.
There's a killer brew. That's an agreement about how you're going to be sentenced, but that's agreements between you and the prosecutor. I'm not a party to that, and I'm the one that has to sentence you. And so I'm advising you now that if I determine that I'm not gonna follow that and I'm gonna put you in a term of jail time, I would give you the opportunity to withdraw your plea at that time, okay?
Okay.
Okay, and then are you currently on probation or parole?
No.
You understand that if you're found to be guilty by way of no contest plea in this matter, this could be a conviction that you may need to report to your employer.
Yes, ma'am.
You may also need to report this conviction on future job applications.
Yes, ma'am.
This conviction could also be something that impacts your ability to travel certain places or to have immigration status approved in certain places. You understand that?
I do.
Okay. You have your witnesses here?
Yes, ma'am.
Okay, well, who is your witness?
My witnesses would be Miss Ashley Sylvester and Mr. Julian Briggs.
Okay, but they don't, can you state your name for the record?
Ashley Sylvester.
Okay, and do you have any restitution information with you today?
I reported all that to the prosecutor that was, or the prosecuting office that was in charge of this 2 years ago when this took place in June 6th, 2 years ago, 2.5 years ago now. They seem to have lost it. I can get a hold of the last landlord and have something stating that he evicted me because of the actions that she took. And I can show you my new lease that I had to move within 30 days. This cost me well over $2,000. Cost me my security deposit and my home, which I resided for 7 years. So I don't know exactly what I would need to provide with you. I did provide an estimate for the door itself, which was over $400.
The estimate was for a door? That's what the restitution
The
is?
door, the frame, it wasn't just the door that came down. It was
The door and
entire
to
frame.
replace the door though, is what you're saying?
Yeah.
Okay. And so your recollection is an estimate of about $400?
It was about $450, yes.
Okay, and so there is, this plea offers for you to plead no contest and pay restitution. Are you objecting to that amount of restitution? An approximate amount of $400? We don't know the exact amount.
I would like to see proof.
You have the right to see proof. And so you're not agreeing to pay the $400 or the approximate amount until you can see the proof. Is that correct?
Yes, that is correct.
Okay. Mr. Broadwood, are you able to locate that information? In the interim, ma'am, I'm going to proceed here. I have a police report here. It's Lansing Police Department, case number 215195167. And so as to the amended charge, or the added count two, I should say, malicious destruction of a building 200 or less, you plead guilty, not guilty, stand mute, or no contest.
No contest.
Okay. Were you intoxicated that day?
Yes, drinks were involved.
Okay, so you don't remember the incident?
I don't remember exactly what happened.
Okay, and so I have a police report here. It states that on or about June 6, 2021, at the area of 2016 Roberts Lane, City of Lansing, Ingham County, State of Michigan, that the victim, Julian Briggs, indicated to officers or explained an ongoing problem with the accused. Victim states the accused is his cousin. Briggs explained that there was a family gathering and that Ashley did not attend. Ashley received a phone call from the accused, and the accused was telling her that his ex-girlfriend was at the family gathering and the family was calling her his girlfriend. The phone was on speakerphone. The accused was telling Ashley how she was going to fight his ex-girlfriend. He was going to fight his ex-girlfriend and so on. Julian and Ashley told Ashley to get out of the phone with the accused and stop entertaining the family drama. The accused began asking what Julian said to her. The accused said she was coming over to their house and hung up. Julian was in the shower when he heard loud banging on the front door. Julian opened the door and noticed it was the accused. Julian told the accused to leave his property and slammed the door shut. The accused continued pounding on the door, threatening to beat them up. As Julian was backing away from the door and Ashley was going to get a phone to call the police, the door busted open. Julian advised the accused never made entry into the home or assaulted anyone. Victim statement from an Ashley Sylvester explained that she also has ongoing issues with Julian's family. Ashley received a phone call today and the accused about Julian's ex-girlfriend. The accused told her that she wanted to fight the ex-girlfriend. Julian told Ashley to get off the phone and to not be a part of the drama. The accused began asking what Julian was saying about her and advised she was coming over. Ashley advised approximately 10 minutes later she was in the backyard grilling when she heard loud banging on her front door. Ashley came to the front door and Julian and saw the accused. The accused was told to leave. Julian closed the door and the pounding continued. Ashley was going to get her phone to call the police when the front door busted open. Ashley told the accused the police were coming and she fled. I'm just waiting for the portion that's highlighted that tells me who the accused was. Where in your report does it tell me this?
Let me approach your. Okay. There was a supplement statement taken from, actually,
Okay, supplemental report taken by Officer Stephanie Kennedy on June 23rd, 2021. Victim Ashley Sylvester stated after Turner came to the door banging on it, Sylvester to leave. When Turner took a step back, Sylvester was able to shut the door and lock the door. Victim Julian Briggs, cousin to Turner, came down and opened the door and told Turner to leave. Nowhere in this report does the officer ever indicate the first name of Turner. So that's not your error, but Are you stipulating that Turner is this defendant?
Yes, sir.
It also indicates here damages were reported to officers. It says Sylvester sent a receipt to law enforcement for a door, $293.99, a receipt for Jake's Easy Installation for $436.63, totaling $730.62 to repair the damages. So that would be an estimate of restitution. According to the police, they received that information.
Yes, Your Honor, and I was able to pull up the quote, and it'd be the quote from Jake's Easy Installation. And that quote, I believe, the officers made a miscalculation because I believe that quote includes the price of the door and the hardware and installation. So the total restitution would be $436.63.
Okay, did you want to see that, ma'am? Or do you dispute that amount now that he's located the evidence?
Parts listed here. Mr. Williams, and then that's it. You would stipulate to that amount of restitution, Your Honor.
Okay, I find the reason for no contest plea to be appropriate, and I'll accept your no contest plea. I find your plea to be made freely, voluntarily, and intelligently. Your witnesses are here, and I'm going to proceed to immediate sentencing. Do your witnesses wish to make a statement?
The only thing I would like to say is that all this took place. in front of
Ma'am, if you want to make a statement, you need to come up to the mic, please, so that my court recorder can hear. You can come all the way up. Let's go to the witness stand just to be safe, and then you need to spell her name. Okay, you can have a seat, ma'am. You can give your statement.
So the only thing that I really want to state is that this took place in front of my children, and Risha had no regard for that whatsoever. My kids, we had just got home from the lake. I was outside grilling. Julian had went upstairs to take a shower at that time. Again, Risha had called me. I told her I didn't care about what's going on at the house, wherever she was at, with her mother's house. I pled with her not to come to my house because me and Risha were friends. She still came to my house. I still pled with her not to continue the drama. And again, this all happened in front of my children. They were watching a movie in my living room and she did not care. And on top of that, she was clutching her pistol in her purse the entire time. So I don't know if her intentions were to shoot my kids' dad in front of them, but that is the only reason why I'm here today.
Thank you. Did anyone else want to make a statement, Mr. Bonowitz?
Sure.
Thank you. Maybe excuse from the stand. You can make allocution.
Your Honor, this was, of course, nearly 2.5 years ago now. Certainly, I know that my client was not making this decision, but I think her situation has improved greatly since then. She's a responsible, productive member of society, Your Honor. She, to my understanding, does not have contact with the victims of this case. I think she sort of removed herself from some of the family interpersonal drama, and I think that's certainly a positive thing. But where she knows that she
And the client wants to make a statement for herself.
Yes, I would make a statement for myself. So since this incident, I have not had no contact with them. Haven't been in trouble since 2014. Whatever did transpire that day happened then. We don't have no contact. Since then, I have moved forward. My grandpa has actually had a funeral since then. They came to it. They wanted to act like they dropped all the charges and everything. We have moved forward. All of this is brand new to me. So I just want to let it go right here and just move on. I agreed to pay the fines, and that's, where I leave it.
It's always unfortunate when the parties at the opposite ends of the table are family. Family is supposed to be your tribe. It's supposed to be your support system. It's supposed to be, its cousins are supposed to be like extension of siblings. You just referenced having a funeral. Where you all share a grandparent?
It's like his grandma's cousin. It's
Okay,
my grandfather.
nonetheless, it's still family.
Mhm.
And nothing, it's very few circumstances, I believe, that involve family that warrant this level of interaction. And just based on the facts that are on the record, there's nothing that I could, or very little I could presume that would warrant a door being kicked in at someone else's residence, because this is not a situation where I have any facts to believe that you had an imminent threat on you, that you believe that someone had did something to you that was so egregious that you just could flip out. I recognize that this was a situation where you claimed that you were under the influence of alcohol, and that probably had some effect. But then the concern is, should you be drinking? Because if alcohol being involved could lead to you standing in court today with a misdemeanor conviction, then maybe you need to be concerned about what you're doing when you're drinking. Nonetheless, whether or not you and your family are in a position to make reconciliation, that's between you all, and I won't get involved in that. You have agreed to pay the restitution. I have your prior criminal history here. I don't see anything else here. Prior criminal history, I don't think that supervision by the court for a matter that happened over 2 years ago is appropriate. So with that being said, you're fine. It's gonna be a $300 fine, plus $75 crime victim rights, $50 state minimum costs, and you'll pay restitution to the victim in the amount of 430. Just have the report. Yeah, the report. The amount of $436.63. Mr. Broderick will get us the restitution form. Do you have any questions?
No, I do not, thank you.
Okay, when are you gonna make your first payment?
Maybe in January.
It's probably gonna be before January. Are you working?
Yes, I am.
Okay, you're making a payment before January.
Okay.
It's November. How much, so now how much is your first payment? That should be a better question.
I will start at $100.
How often do you get paid?
Every 2 weeks.
So when's your next pay period this month?
Around November 24th.
You'll pay $100 on November 24th, and you'll make a $100 payment monthly on the 24th of each month.
Okay.
Have any questions about how you make payments?
No, I do not.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. On the record in the matter of the people of the state of Michigan versus Sheena Scutt, file number 23-01015, counsel appearance.
Jeff Prados on behalf of the people, Your Honor.
Thank you, Mr. Green, behalf of the defending, I am approaching the podium to my right.
Okay, today was the date and the time that was set for a PA 53 and a jury trial. What's going on with this PA 53? Did I dismiss that? I don't see it set. The parties neighbors.
Yes, Your Honor.
Okay, I dismissed this. Okay, this matter was set for a jury trial. And my understanding is that there's some new or recent evidence?
Yes, Your Honor. After some, upon receiving defendant's proposed exhibit witness list, there were witnesses that were listed on defendant's witness list that the people were not aware of prior to the list being submitted on Friday to the court. Under the defense made demands when they filed their substitution of attorney, while not specifically referencing demands that would be listed under MCR, I believe it's 6.201A, under MCR 6. It is 6.615. Sorry, it would be 6.610 E, discovery and misdemeanor proceedings, that if demands are made under MCR 6.201A, that applies mutually, Your Honor. So the people would be motioning for an adjournment of this matter so that we can review what was sent by the defense, and so we can get in contact with defense witnesses and have them interviewed by LPD in order to properly adjudicate this matter, Your Honor.
Mr. Green, who are the witnesses that he's talking about?
It would be, they are in the courtroom, Your Honor.
I have a witness list here. I have a Sheena Scutt, Shane Scutt, Daniel Bywater, Charlie Scutt, Evan Scutt, and a Rosalie Bywater.
Those are the individuals, Your Honor.
Okay, and so were these names that were a part of the police report?
They were not, Your Honor. The only name I believe that was part of the only name that was directly mentioned in the police report was Miss Scott.
Okay, so this information, Mr. Green, was provided to you from your client?
Yes, Your Honor.
Okay, and why didn't you properly notify him?
We, in preparation for trial last week, Your Honor, I met with Ms. Scott and we went through those other witnesses. And I was aware of them, so to speak, and communicating with her, but when we were preparing for trial, we found out there'd be witnesses that'd be important for the defense in defending our case.
I recognize that, but now I ask the question.
We didn't have really a chance to meet on this matter until last week, Your Honor. It's just been a crazy schedule.
This is the second time this was set for trial.
Sure.
How much time is your office looking for, Mr. Brodowitz?
I believe only a couple of weeks would be necessary. I mean, if I could get, I think 3 weeks, I think that would be sufficient. You know?
And you have the information that you need to make contact with these individuals?
I will get that information from Mr. Green, Your Honor, and provide it to LPD so that they can get someone to interview those individuals.
These people are here today? Mr. Green?
Sorry,
These witnesses are here presently?
they are ready. They're right behind me.
Oh, okay, so then we'll get their contact information to Mr. Brodowitz today, correct? Have any final pre-trial? I'm gonna set it for new final pre-trial because new witnesses, new investigations could lead to new offers. So I'm not gonna set for trial until after another final pre-trial. 27.
Before they leave today, I'll provide the contact information to Mr. Brown.
You need to go up probably more than November 27th because it's the holiday. No way his office is contacting the people. December 4th at 8 AM is the final pre-trial. And a jury trial. Yes, please. January 16th at 8 AM. January 16th at 8 AM. Date for the jury trial. How many witnesses were you planning on calling, Mr. Rodowitz?
I was only planning, I believe, on calling 3, Your Honor.
Let me get another jury trial date. Because if that date won't go, I'm gonna have a problem texting. February 13th at 8 AM. February 13th at 8 AM.
Thank you.
Thank you. Do you have any questions today, Ms. Scott? Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing for the defense, Your Honor.
That's all we have on this matter today. Let's see. Okay, do we have Marcus Baptiste here? Okay, on the record in the matter, the people of the state of Michigan versus Marcus Baptiste, file number 23-02804, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Represents Miss, is it Mr. Lee?
Yeah, he's just out.
Appearance, please.
Assistant Public Defender John Lee on behalf of Marcus Baptiste.
Today was the date and the time that was set for final pre-trial. My understanding is that the offer, at least the offer I have last listed, was that the defendant was to plead guilty to an added count 2 of assault and battery with no objection to sentencing under HYTA. Do we have necessary witnesses here?
Your Honor, I have, if you're doing the hallway in the courtroom prior to coming to the courtroom here, I have not seen the complaining victim here, so I believe we do not.
In that event, Your Honor, we would make a motion to dismiss.
Motion to dismiss without prejudice is granted. That means the case is dismissed today, but the people do have the right to reissue the charge against you within the statutory time frame, so long as the witness appears and is ready to proceed, okay?
Yes, thank you, Your Honor.
You're welcome. Do you have any questions today, sir?
No, ma'am.
Any additional matters for the record?
No, ma'am.
Nothing, nothing from the people, Your Honor.
Nothing to the defense. Thank you.
We're all set. Thank you. On the record, in the matter of the people of the state of Michigan versus Jessica Gonzalez, file number 23-02346, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor. Prince Green is going to be standing right for Mr. Bronson.
Oh, Okay, counsel appearance, please.
Thank you, Vince Green, on behalf of the defendant, Ms. Gonzalez. I'm covering for Jeffrey Rothstein.
Okay, very good. Today was the date and the time that was set for final pre-trial. I have a note here that the offer was for the defendant to plead to an aggravated domestic violence in file number 23-02478FY, and that the people would dismiss this case. What happened in the felony file?
In the felony file, Your Honor, that was dismissed because the complaining victim failed to appear. Again, after viewing the courtroom and the hallway, it appears that the complaining victim has not appeared again, so the people would be unable to proceed at this time.
Mr. Reed?
Hey, we have motion for dismissal, Your Honor.
A motion to dismiss is granted without prejudice, so that means that people can reissue the charge against you within the statutory time frame if the witness later proceeds and is ready to proceed against you, okay? Yes. Do you have any questions? No, you're on. Okay, we'll get you a copy of the dismissal. You're all set. Thank you.
Thank you.
On the record, in the matter of the people of the state of Michigan versus Anthony Devon Price, file number 22-02655, counsel appearance.
Jeff Roberts on behalf of the people, Your Honor.
Jacob Rowling on behalf of Mr. Price.
Okay, Mr. Price, today's the date and the time set for final pretrial on an aggravated assault. Was there an offer on this?
There was not originally, Your Honor. However, I believe Mr. Price has picked up another case which is set for a pretrial this afternoon. And so there was an amended offer made on this case, and that would be for Mr. Price to plead to an added count 2 of assault and battery on this case, and 1 count of assault and battery on the case set for this afternoon, which is 23-03212 SM. People would dismiss count 1 in that case, Your Honor.
So, Mr. Baptiste, someone you want to talk to?
Oh, no,
Who are you talking to?
I'm talking to my father.
You think I'm stupid?
No, he was talking. to me.
No, you think I'm stupid? Stand up, stand up. Don't talk when I'm not talking to you. You think I'm stupid? You think I didn't see what you were doing? You did it more than once. Who are you talking to?
I wasn't talking to anyone.
Who were you motioning?
I was just motioning with.
Who are you motioning to?
I thought Marissa was pretty good, so.
Oh, and you asked her to call you because I saw you.
No,
I saw you do, you think I'm stupid?
no, I don't.
You didn't do this?
I did that.
We have it on recording.
I know, I did that. I was just,
So why are you lying when I asked you who you're talking to?
because I wasn't trying. I was just.
Okay. You don't do that in my courtroom. You don't motion to people who are sitting in jail. You sit quietly and wait for your case to be resolved, which yours was, in your favor. Don't get yourself in trouble
I'm sorry.
while you're sitting in the back of the courtroom, okay?
I'm so sorry.
Thank you. Behave yourself. Okay. Do we have witnesses here on this matter?
As of this time, Your Honor, I had not seen the complaining victim in this matter. However, the complaining victim has shown up. I attempted to call her on Friday. I did not have any contact with the complaining victim on Friday. However, she has appeared at every prior court hearing, Your Honor.
Your Honor, in light of the witness's non-appearance today, he was move for dismissal at this time.
She appeared at the October 16th final pretrial.
I believe that was the last final pretrial. Yeah. Yes, she did appear for that one. And she did appear at the original pretrial date as well, Your Honor.
Okay, but you can't make contact with her now?
I did not have any contact with her on Friday. I have not had a chance to attempt to make contact with her today, Your Honor.
Okay, my concern is that the final pretrial on October 16th was reset to today because your client, Mr. Raleigh, did not appear timely. And so that's why you reset it. So he got a chance, we're gonna give her a chance. So we'll reset this matter for another final pretrial. Maybe hopefully we can get everybody here.
Your Honor, I don't know if you want to discuss the other matter Now we're just set for this afternoon, but,
He has another matter this afternoon.
yes,
Yes, it is just set for pre-trial.
and we'd be asking to set that for.
That matter will be set for final pre-trial as well. We'll set it for the same dates.
4th at 8 a.m.
December 4th at 8 a.m. And then what's the offer, Mr. Brodowitz?
As I stated, Your Honor, it would be for Mr. Price to plead to an added count two, on file 22-02655 SM, to plead to an added count two of assault or assault and battery. People would dismiss count one, with also an offer of pleading to count two, I believe it was count two on file 23-03212 SM. People would dismiss count one on that file, Your Honor.
Okay, and so you've heard the offer, sir, Mr. Price?
Yeah.
Okay, that offer expires at the time of your final pretrial. You understand that? Have any questions? Okay, we'll see you on December 4th at 8 a.m. on both of these files. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. That would be it for my final pretrial, or someone in more status. On the record in the matter of the people of the state of Michigan versus James Williams, file number is 19-04381. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of James Williams, who's at the courtroom.
I also have file number 18-05183, which is in warrant status, Mr. Williams, because you failed to pay your fines and costs. States here, you owe $1,374 since 2018. Looks like Judge DeLuca, who's now retired, but just so happens to be across the hall today, was the matter you had this case before. You've not made any payments. Why is that?
On which case?
File number 18-05183 FY, which is started off as an aggravated stalking, which is a felony matter that you had before. It's like originally for Judge DeLuca, then it was before Judge Ward. And so you pled guilty to adding count two of stalking. You have fines and costs in the amount of $970 that was referred to collections. You've seen the magistrate before this and multiple times. The last time you saw her was in August. She told you that you owed $1,374. You said you had no idea about this. She referred it to collections upon your release. So you were in custody when you spoke to her about it. You were released in August. You still made 0 payments. So now you can't use the excuse that you didn't know anything about it. Now you just have to tell me why you didn't pay.
So the like she explained to you, it was a few years ago, and I didn't know when I got locked up for these warrants. And so once I got locked up for these warrants, I had to come up with money for housing and to get out. I can make a payment today. I have been making other payments like child support that I neglected for a couple of years as well while I had these warrants. So I've been clearing up my child support. I had to get my housing straight. And I had to bond out of jail as well. So like I said, I
How
can
much you
make a
gotta pay
payment.
today?
I can pay $150 today.
And when are you gonna make your next payment?
So would it be a monthly thing? Can I pay $50 a month? And if
You
I pay
absolutely can.
$150 today? Okay. pay $150 a day and then $50 a month.
Okay, I'll note that you'll make a payment of $150 today and $50 per month on the 13th of each month, okay?
Yep, yes, ma'am.
That will keep you out of sitting in jail on money on that file. And then we have here matter set today for final pretrial on domestic violence. Do we have witnesses here?
This time, Your Honor, I believe the people have had no contact with the complaining victim in this case, and they have not made their presence known to me in the courthouse today, Your Honor.
Counsel?
The defense would make a motion to dismiss, Your Honor.
Motion to dismiss is granted. The case is dismissed without prejudice. That means the people have the statutory right to reissue the charge against you within the allotted time frame if they make contact with the witness and the witness is ready to proceed within that statutory time frame. Okay, sir?
Yes, ma'am.
We'll get you a copy of your dismissal. Do you have any questions?
Where do I pay the $150?
We're gonna take you right over to the window in just a moment, okay?
Okay.
Thank you. You can have a seat. On the record, in the matter of the people of the state of Michigan versus Tyrone Hooper, file number 23-02102. Mr. Hooper, today's the date and the time that was set for show cause. That's because you owe $200 on this matter. It looks like you pled guilty to count 2, which is driving while license is suspended, but you never paid the fine. You were supposed to pay $50 the first of every month, starting in October, but I see you're in custody. You're muted. Let me see if I can get this unmuted. Joe, let me unmute. It's clear.
Can you hear me?
Okay, can you hear me, sir? Mr. Hooper? Uh-oh. He's gone now. They made a payment when?
It's not today, it's for today.
How much?
50.
Okay, well, they won't call the jail to put him back on because someone made a payment on his behalf today. Let's end the Valencia here for- Okay, who's representing her? And who has Mr. Jackson has an interpreter? Who's representing Mr. Jackson?
Noel Jackson.
Yes, Your Honor.
Noel Jackson.
Are you ready to proceed?
I'm sorry.
Are you ready to proceed?
Yes, we are ready.
On the record in the matter of the people of the state of Michigan versus Noel Jackson, file number 23-00617. We need a prosecutor. Just leave and look for it.
So go to the distance away.
Council appearance.
Jeff Broadway on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Noel Jackson.
Mr. Jackson, can you hear us?
Yes, ma'am.
It's pretty good understanding. Then we have Mr. Abdallah here.
Yes, Your Honor.
Please raise your right hand, Mr. Abdallah. You solemnly swear or affirm that you were interpreting the matter now before the court completely and accurately and not divulge confidential communication, so help you God.
Yes, Your Honor.
Thank you. Today's the date and the time that's set for a pre-trial.
Leo ndio siku tumekuja tuanze kwamba hizo habari. Asante.
And this.
Thank
this is
you.
for- Thank you. It's for an operating while intoxicated.
Uko unaendesha
Second.
gari ukiwa umelewa.
And the last court date, he was denied drug court at 55th.
Nasema siku ya mwisho kwamba uliletwa mahakamani kwamba ni wakati ulifanya hivyo.
So we were adjourning so he could be screened for drug court at 54B.
Sema kwamba ni hapo sasa wataipeleka mbele kwamba ili uende ukachukuliwe vipimo.
How we proceed?
It is just to clarify, it would be sobriety court at 54B, Your Honor, sobriety court at 55th.
Nasema kwamba ni wewe ulikuwa umetumwa kwamba ni uende kwamba ni kwa hiyo sobriety court kwamba ni 55B kwamba.
And based on conversations with Mr. Lee, I believe Mr. Jackson is eligible for sobriety court, and we have signed the transfer order, Your Honor.
Nasema kwamba ni tukaona kwamba ni ndio kwamba ni Jackson kwamba ni yeye anakaribishwa na amekubaliwa kwamba aende kwa hiyo sobriety court.
Yeah, the order.
I do have one problem with the order, though. The defendant himself has not signed it. Is it possible that I can get the defendant's permission to sign it on his behalf? Would the court accept that?
What 54B would accept, I don't have a problem with it.
Nasema kwamba ni kama 54B wakimkubalia hakuna shida, sina shida nayo.
Hasa hii itakuwa ni ya nini?
He's asking the 54B, what is that for?
You want me to answer?
54B is the court that he's going to do his sobriety court. He was screened to do specialty court there, correct?
Anasema kwamba ni hapo hiyo sehemu ni ile umetumwa kwamba ni ukafanye waende wakupime kwamba ni sababu ni mara ya pili umepatikana na kitu cha ulevi.
Is that correct, Mr. Jackson?
Hiyo ni ukweli, umetumwa hapo?
Mimi sijatumwa hapa, lakini kama wananituma mimi ndaenda.
Yes, I will go there. I was not told to go there, but if I asked to be going there, I'll go there.
No, my question was he screened to do sobriety court?
Umeenda kwa kuchukuliwa tayari vipimo hapo kwa hiyo mahakamani wengine upande wa East Lansing hapo?
Hapana.
No, he didn't get a screen on there.
Okay, it sounds like you might want to have a conversation with your client and you might want him to sign that paperwork himself.
Yeah. I think
Inaonekana kwamba ni lazima kwamba ni muonane na mwanasheria yako alafu sign hiyo karatasi.
Do you want me to reset this in person so that we can have an interpreter? Okay.
Kwamba ni tutaiweka hii alafu tukuje macho kwa macho alafu tukue na mtafsirishi hapo.
Haina shida.
No problem.
Okay.
November 27th at 9.
November 27th at 9 a.m.
Mwezi wa 11 tarehe 27 saa 3 kamili.
Mr. Jackson, you need to appear in person.
Natakikana ukuje hapa macho kwa macho.
Asante sana.
Thank you so much.
Thank you. You're all set.
Tumemaliza.
Nawaza hiyo anirudie tarehe zenye ndafika hapo.
He wants to repeat the date. Can I tell him the date?
Yes, November 27th.
Yeah, mwezi wa 11 tarehe 27 saa 3 kamili.
27.
Yes.
Asante sana.
Asante sana.
I heard that online, King. Thank you.
All right, thank you. Thank you so much, Anna.
Have a good
May I
one.
leave?
You may leave. Thank you.
You're welcome.
Okay, on the record in the matter of the people of the state of Michigan versus Amber Valencia. File number 23-02241. Mr. Carter on that one?
Showing that.
Where's Mr. Carter? I didn't see him all day. Okay, Ms. Valencia, we don't have your attorney here. Okay, we do have a substitution for Mr. Carter. I'm not sure if Mr. Carter is. Ms. Valencia, we're gonna have to reset your matter because your attorney's not here. November 20th at 10. Yeah. November 20th at 10. Okay, Miss, that's enough time to beat the jail. Miss Valencia, I can't unmute the there. Oh, what happened? I can't unmute her. And I'm muted for a minute and then it muted back up.
You reach home?
Mr. Jackson, you're free to go.
All right, thank you so much, Anna.
Thank you. Can you hear me, Miss Valencia?
Yeah, I can hear you.
Okay, very good. We have to reset your matter because your attorney didn't come. Okay?
That's okay, but I was ready. I was gonna go to rehab this week.
Okay, where are you going to rehab?
Glass house.
Okay, it says you're supposed to go to rehab. They'll need to notify us. Your attorney should have called, let us know, so that your bond can be amended so you can be transferred there, okay?
Okay, thank you.
Thank you, you're all set. On the record in the matter of the people of the state of Michigan versus Lindsay Buffington, file number 20-03146. Appearance, please.
Jeff Reynolds on behalf of the people.
Assistant Public Defender John Lee on behalf of Lindsay Buffington.
Okay, and then Ms. Buffington, I also have the people of the state of Michigan versus Lindsay Buffington, file number 23-02881 SM. This is a matter in which you allegedly received a citation for on or about September 12th, 2023 at approximately 11:37 a.m. at the area of 1207 Princeton, City of Lansing, Ingham County, State of Michigan, allegedly having an unlicensed dog. And so that's a misdemeanor with the maximum penalty of 93 days in jail and or $500 in fines. You have the right to be represented by an attorney, and you have the right to have a trial in that matter. If you cannot afford to hire an attorney, you can request to have the public defender's office represent you at the expense of the public. Do you understand that?
Yes.
You were scheduled to be present to be arraigned on this matter on October 20th. It says that you failed to appear, so that's why this matter is in warrant status today. I'm arraigning you now to address that warrant. And so did you want to make a request for a public defender on this matter?
Can I just make the payments? I was in the hospital and I had called and they were supposed to set a new date, but I never got a letter in the mail with a new court date.
Okay, well, I just need you to answer my question. Do you want an attorney on it? Because you have an attorney on your other matter. You could likely qualify on this one. And as of right now, there's no payments for you to make because we haven't resolved anything.
Yeah, can I have an attorney, please?
Okay, so I'll note that you are requesting court-appointed counsel. You have the right again to a trial. You have the right to require the prosecution to prove your guilt beyond a reasonable doubt by proving each element of the charge of unlicensed dog beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You have the right to cross-examine any witness that they call against you at trial, and you have the right to call your own witnesses or present evidence at trial that you believe further defense to this charge. I'm going to enter a plea of not guilty on your behalf, set your bond in the amount of 100 personal recognizance. You have not yet completed information to be assigned an attorney on this matter. The standard offer from the prosecutor on an unlicensed dog is to get the dog a license and provide proof, and they'll dismiss the case. That's the standard offer. If you don't have the dog anymore, or you have some other reasonable defense, you'll let your attorney know so that you can talk to the prosecutor about that, okay?
Okay, thank you.
We'll get you a pretrial date on that as well in just a moment. And then as it relates to the sentencing on the assault and battery, I do have a report here that was prepared on November 6, 2023. Mr. Lee, you got a copy of that report?
Yes, I did, Your Honor.
Are we making corrections, updates, or deletions?
No corrections, updates, or deletions, Your Honor.
Okay, you can make allocution.
Thank you, Your Honor. We would ask the court to consider that Ms. Buffington has fully cooperated in this matter. She pled, she accepted responsibility. Even the pre-sentence investigation report notes that she showed contrition, accepted responsibility for these acts, which is appropriate and expected. She's a mom of 2 young children. And has displayed the appropriate level of acceptance of responsibility in this case. She intends to work hard to complete her probation. She understands that her height of status depends on that. The only thing that we would ask the court to consider is perhaps a shorter term of probation. They are recommending 9 months. We think that 6 months would be entirely sufficient for her to complete an anger management class and demonstrate refraining from drugs and alcohol. So we would ask the court to consider a 6-month probation on Ms. Buffington's behalf.
What happened to? I see, I just took care of one warrant, but what happened to the matter in Isabella County? Did you have a warrant?
To the report, looks like there's a warrant outstanding.
Ma'am, do you have a warrant outstanding in Isabella County?
Not that I know of.
The Pleasant Grove animal abandoning cruelty?
Oh, that was supposed to be, they never contacted me about that because it wasn't my dog.
Okay.
My ex was supposed to take care of that.
Okay, I just looked, and you might want to confirm and make sure they're taking care of that, because it shows here on our report and on your criminal history that you're in warrant status.
Okay, I will definitely call them and see what's going on with that.
And I took care of the other warrant that you have for our court. Okay, did your client want to make a statement before I sentence her?
Ms. Buffington, do you wish to make a statement to the court?
I know I'm supposed to do the dropping and everything. It's just gonna be hard for me because I don't have a vehicle and I'm a single mom of 3 kids and a 1-year-old and a 4-month-old. And I just don't want to be like in violation of probation, and I don't have a job to come up with the money to be able to pay for the drops every time. And I don't have anyone to watch my kids to even be able to go drop.
How does this make you a good candidate for probation then? You have a lot of, what you're telling me, your statement was only to let me know of what you're not able to do and to be successful on probation. So how would you be a good candidate for probation, ma'am?
I mean, I'm gonna try my hardest to do it. I mean, I would rather do probation than jail time.
Well, it wasn't just probation. There was a no objection to the Homes Youthful Training Act. So that means that you would need to be successful on probation. And if successful, and I grant you sentencing under HIDA, that means that you would not have a conviction on your public record. This will not go on your public record. But that means you have to be able to do what it takes to get it done. And so this is a matter where you have now a conviction for one count of assault and battery.
Okay.
You got to decide if you're going to be successful or not. I can't make that decision for you. I can give you an opportunity, but you're the one who's going to have to decide. Although it may be challenging, I will make it happen. Because guess what could be more challenging? Trying to raise these children with an assault and battery on your public record. That could be more challenging. It could have impact on your ability to get certain places to live. It could have impact on your ability to get jobs in certain places. It could have an impact on your ability to advance your education.
Okay, I'm gonna have to make it happen.
That's up to you. You don't have to make it happen. You could go to jail. That's up to you, ma'am. I don't have any control over that. I'm willing to grant it to you because you're eligible for it. And I think it would be meaningful for you and for the betterment of your family and your future for you to do a term of probation with the benefit of HIDA. That's the point of it, is to make sure you don't end up with this on your long-term record. But that's up to you, ma'am.
Yeah, I want to do the probation.
Okay. And again, the report that I have, and I've already gone over your prior criminal history at this point, it states that they believe you to be a good candidate for probation and a good candidate for a term of probation under the HYTA Act, and that you would, or you had indicated remorse for the situation and remorse for putting your hands on the young lady. And we don't have the victim here today, do we? Is that correct?
I believe so.
Okay. And it's recommended that you attend some anger management classes that are offered by Crystal Ray, and that the class may teach you a better way of emotional management and non-physical releases. I think the term of probation in the HYTA is appropriate. I will grant your attorney's request for a lesser term than 9 months. We'll do 6 months of probation. While on probation, you have the following conditions. You're not to engage in any assaultive or threatening behavior. You're not to have contact directly or indirectly with an Anastasia Schultz or Shelby Lucas. Do you understand that?
Yes, ma'am.
You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol or marijuana or other controlled substance that you do not have a valid prescription for. You're not to be at any bars or nightclubs, and you are required to submit to random preliminary breath testing and urinalysis testing, and you are responsible for the cost of that. Do you understand that?
Yes, ma'am.
Okay. You are going to be required to obtain and maintain employment as part of your probation status. completed the 11th grade. Is that how far you went?
Yes.
Okay, in lieu of employment, because you are a single mom, I'll allow you to provide proof that you are enrolled in completing a GED or high school education in lieu of employment. You need to do one or the other, but you're gonna do one or the other. Do you understand that?
Yes, ma'am.
I'm gonna order that you complete anger management and provide evidence of that to your probation officer, okay?
Yes, ma'am.
And again, they offer those courses at Crystal Ray. Do you have any questions about your probation status at this time?
Do I call my probation officer or will she call me?
We'll get into that in just a moment, but I'm asking if you have questions about the terms and conditions that I just went over.
No, ma'am.
Okay, so as to fines and costs, there is a $75 crime victim rights fee that per statute I must assess, plus a state minimum cost that per statute I must assess. 6 months of probation is a $30 per month oversight fee for each month, so it's $180 for probation oversight fees. I'm gonna waive discretionary fines and costs. So your total fines and costs is $305, and you'll be advised when you go over my judgment of sentence that you'll make monthly payments on that. To answer your question about whether or not you'll be in contact with them, you're going to actually need to report to them in person within 48 hours.
Okay.
So once you do that, they'll have your correct contact information and they'll get you all set up. Actually, you don't need to report in person. You can report via phone. You can report via phone within 48 hours. Make sure they have accurate contact and phone information for you. And then that way, once my judgment of sentence is complete, they will have you sign off that you review and understand the terms, okay?
Okay.
And then lastly, as it relates to the fines and costs, I just told you it's $305, and I recognize you're probably on a fixed budget. What I would prefer that you do to ensure your success is that when your funds are limited, you prioritize doing your random preliminary breath testing because there's a cost to that versus making the monthly payments. At the end of your probation, if all I have is that you have complied with all of my orders, but you didn't make the payments, I can address that, okay? Without penalizing you. I can't address you skipping out on your preliminary breath testing without penalizing you, okay?
Okay.
Lastly, there's an advice of rights and plea information sheet. Let me also note here that I am granting HYTA. I am granting HYTA status. Lastly, there's an advice of rights and probation early discharge. It states you have the right to request early discharge once you've completed half the original term ordered by the judge. Your probation officer may, but is not required to. They could file a notice with the judge once you become eligible. They would send a copy of that notice to the prosecutor's office, and the prosecutor's office has 14 days from receipt of that notice to file any written objections to your early discharge. You can make your own request for early discharge once you become eligible, and you become eligible once you've completed all the required programming. In your case, I said you need to be enrolled in a GED or high school program and or working, and that you needed to do anger management. Once you've completed those things, or at least in the process of completing high school, you can request early discharge, but you must not have had any violations within the 90 days prior to that request. Do you understand that?
Yes, ma'am.
You would make your request by completing a MC 512 form, which is the notice regarding eligibility for early discharge. You would tender a copy of your request to the prosecuting attorney's office. They have 14 days to respond to your request. You're also going to turn in a copy of that request to your probation officer, okay?
Okay.
If a hearing is scheduled to address your request for early discharge, you have the right to hire an attorney to represent you. You do not have the right to court-appointed counsel if a hearing is scheduled for that purpose, okay?
Okay.
Do you have any questions about that?
No, ma'am.
Okay. Do you have any questions about your fines and costs or your probationary terms?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing for the defense. Your Honor.
Okay, good luck to you, ma'am. You're all set.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Joel Christie, file numbers 23-02362, 2565, and 2691. Council appearance.
Jeff Braddock's on behalf of the people, Your Honor.
And Mr. Christie, state your name, please.
Joel Christie, Your Honor.
Okay, and we reset this matter because this is the matter of livestock involving some chickens, and you needed more time to work on bringing things into compliance. Mr. Brodowitz, do we need more time or is he all set?
Your Honor, at this point, I still have not received any proof of compliance from Mr. Christie. The people would ask then that these matters be set for a final pretrial, Your Honor.
Mr. Christie, what's going on?
My battery on my phone's dead, so I couldn't show the pictures of my progress.
Okay,
I was gonna try to email them to him so that we can, we're wasting the first time.
so for final pretrial and jury trial.
So the final pretrial November 27th at 8.
November 27th at 8 a.m.
And jury trial January 9th.
January 9th at 8 a.m. is the date and time set for jury trial. Do you have any questions today?
Your Honor.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
You're all set. We'll get you a copy of your notices.
Your Honor, can I get the dates just one more time?
November 27th and January 9th. Okay. Do we see Fullerson here? Garza? No? Person? Adrian Person? Present? Javon Shaw, present? On the record in the matter of the people of the state of Michigan versus Marissa Carberry, file number 20-01754, council appearance.
Jeff Braddock's on behalf of the people, Your Honor.
Jacob Riley on behalf of Ms. Carberry.
Okay, Ms. Carberry, you can hear us, correct? Looks like she might be frozen.
That's not Ms. Carberry. Ms. Carberry was on Zoom from home.
No, I know who she is. She's on there. She's frozen though.
Oh,
That's why she won't pop up. Okay, Ms. Carberry, can you hear us?
Yes.
Thank you. Okay, and then today was the date and the time that was scheduled for a pretrial on operating while intoxicated. Second, I think she was going to be screened for sobriety court. And then for the record, Ms. Carberry, there was a Mr. Baptiste in the courtroom. He thought you were attractive, okay?
I don't get my boyfriends from court.
It's a good policy to have. Nonetheless, did she get screened?
Your Honor, after further consideration, Ms. Carberry has declined to participate in that court. She has accepted a plea offer from the prosecution.
What's the offer, Mr. Brodowitz?
The offer would be, and I believe this would be to plead to an added count 2 of operating while intoxicated, first offense. I notice, Your Honor, with restitution for MSUPD for their OWI request, and then people would dismiss count 1, the operating while intoxicated second offense.
Oh, Ms. Carberry, you want to accept an offer to plead guilty to operating while intoxicated first offense?
Yes, please.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do.
Thank you. You can put your hand down. Okay, you have the right in this matter to proceed to a trial, and you have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes.
You have the right to have the prosecutor prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to cross-examine or question any of the witnesses they intend to call against you at trial. And you have the right to call your own witnesses or present evidence at trial that you believe further defense to the charge. You have the right to remain silent and not have silence at your trial be used against you. Do you understand that?
Yes.
And you want to give up all of those rights today in order to plead guilty to operating while intoxicated?
Yes.
Anybody making any promises to you in exchange for a guilty plea?
No.
Anybody make any threats to you to get you to waive your rights and plead guilty?
No.
Are you currently on probation, on parole, or have any other matters pending?
No.
You understand that a guilty plea can result in a conviction that you may need to report to your current employer.
Yes.
A guilty plea can result in a conviction that you also may need to report on a future job application. You understand that?
Yes.
A guilty plea could have impact on travel or immigration status that you may seek in the future. So you may want to go to Canada and they could deny you entry because of this conviction. You understand that?
I understand.
As to operating while intoxicated, first offense, how are you pleading?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes.
Factual basis, please.
Your Honor, Ms. Carberry, going back to the early morning hours of March 13th, 2020, were you operating a vehicle on a public road, being Michigan Avenue in the city of Lansing?
Yes.
Had you had some alcohol drinks before operating that vehicle?
Yes.
Do you recall what you had to drink?
Angry Orchard?
And is that an alcoholic beverage?
Yes.
Okay. Were you stopped by police on Michigan Avenue?
Yes.
Did the police tell you why they were stopping you?
Yes.
And what was the reason for the stop?
I was speeding.
And did the police ask you to do some field sobriety tests at the stop?
Yeah.
And after those tests, did the police determine that they have reason to take you into custody on suspicion of operating while intoxicated?
Yes.
Did you then submit to a chemical test?
Like a breathalyzer?
I believe it would have been a data master. It is a breath test, but it's different from breathalyzer. Yes.
Yes.
Okay, and you acknowledge that the result of that test was above 0.08 alcohol
Yes.
level. And you have no reason to dispute that result, is that correct?
No. Correct.
Any questions from you, Mr. Brodowitz?
People are satisfied with the factual basis.
Court is also satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. The matter is set for sentencing January 9th at 9 o'clock in the morning. You need to report to our probation department no later than Wednesday of this week at 10:30. They'll get you scheduled for a pre-sentence interview, okay?
Okay.
If you've not already undergone a alcohol and substance abuse assessment, you are being ordered to undergo one so that I know how to best sentence you, okay?
Okay.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set for today, ma'am. Thank you.
Thank you.
On the record in the matter of the people of the state of Michigan versus Cory Gos, file number 20-03656. Counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Cory Gos, who's standing to my right.
Okay, we were setting this out for a review. Because he's waiting to be placed in residential treatment, is that correct?
He is continuing to wait.
Okay, well, we have no update as to how long that's gonna take.
No, we have no
Okay.
update as to how long that will take, and based on my experience in other cases similarly situated, it may be a long, long time.
Okay, we do have an update in our file. It says that he was ordered, the order was for May 2023. There's a 6-month waiting period right now for a bed, which wouldn't that put us at today? So
That would be
it should be
about
coming anytime then.
Anytime now.
So we're getting close.
However, I have an alternative possibility that I'd ask the court to consider. His mother, who lives in Alabama, has access to an excellent mental health care facility there and a program that he could participate in. Currently, he's participating, I think he counsels once a month at CMH, and he gets an injection every 3 months. His father's here in the court with him, and he provides support to Cory. His mother, however, lives in Wetumpka, Alabama.
What's that?
Where is that?
What's the next two? That's the Montgomery, okay.
And I would ask the court to consider modifying his bond so that he could go to his mother's house in Wetumpka, Alabama, participate in the mental health treatment there that's available immediately.
What's the treatment there? We don't have anything? We don't have any names or
I
programs?
don't have a name, Your Honor.
Do we have any assurance that he's already been accepted to do that there?
I have no assurance on that, Your Honor.
Well, we demand reasonable assurance.
Okay. Your Honor, I should also mention to the court that if we go to trial on this, it's my expectation that the court will find out that he was given some credit cards by a couple of young ladies and said, here, go ahead, use these. He did use them. He bought a chicken dinner and 2 cans of beer and a pack of Newports. That's the crime bill.
Yeah, I don't have any reason to dispute that. And it's from 2021, but the prosecutor is holding fast on this.
If I get more details on the Wetumpka, Alabama mental health situation, can I approach the court?
Please do.
Between now and the next hearing?
I'm just gonna reset it 1 week and that'll give you to provide opportunity to provide us additional information and provide that to the prosecutor's office and the prosecutor's office to review this file and see if it's in the interest of justice to continue to hold it over.
Thank you very much, Your Honor.
November 20th at 10:30.
The 20th at 10:30. Do you have any questions at this time, sir?
No.
Well, since your father's here, do you have any questions, sir?
No.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense.
You're all set. On the record in the matter of the people of the state of Michigan versus Crystal Drews, file number 23-03185, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Rowley on behalf of Ms. Drews.
Okay, and Ms. Drews is present. You can hear us, Ms. Drews?
Yes, ma'am.
Today was the date and the time that was set for a pre-trial and an attempt police officer assault, resist, and obstruct, and a trespass. How are we proceeding on this?
At this time, Your Honor, people have made an offer for Ms. Drews to plead to count 2 of trespass, dismiss count 1. With that, I would leave it to the defense, Your Honor.
At this time, we would ask that this matter be set for a final pre-trial. Certainly we'll have a final decision by that point, but given that some matters we need to discuss before.
I'll set the matter for final pretrial. I will not require witnesses to appear. December 4th at 8 a.m. December 4th at 8 a.m. is the final pretrial. Jury trial. February 6th. February 6th at 8 a.m. is the jury trial. Do you have any questions today, Ms. Drews?
What are we doing a jury trial?
Excuse me? You said what?
Never mind. No, I don't have any questions.
Okay. Any additional matters? No problem. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
You're all set, ma'am.
Thank you.
You're welcome. In the matter of the people of the state of Michigan versus Jessica Rose Hodge, file number 23-02886 and 887. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Riley on behalf of Ms. Hodge.
Today was the date and the time that was set for trials on dog backs and license cases.
At this time, Your Honor, the people would, I do not believe we can appearance on this, but the people would extend an offer that if Ms. Hodge would provide compliance with this matter, people would dismiss both tickets, Your Honor, both counts on the ticket, Your Honor.
Mr. Raleigh.
Your Honor, we'd be requesting another pretrial date so that we can see about that compliance. In the meantime, I wonder if I could get a good phone number from Ms. Hodge. I believe I have one yet.
Yes.
Ms. Hodges, is your number ending 5125?
Yes.
That's the one you have?
That's another one I have.
Okay, we have 885-5125. Okay, your attorney is trying to get in contact with you, okay?
Okay.
If you don't hear from him by today, you call him tomorrow, okay?
Sounds perfect.
Okay, we're gonna reset this matter. The offer from the prosecutor, which is standard on these matters, is that you bring proper identification for the dog licensing and they'll dismiss this, okay?
Perfect. Thank you.
December 4th at 10. You're all set for today, ma'am.
Thank you.
No problem. Okay, let's see. I see a person identified as Meredith Clark.
That's me.
You have a case number?
I don't. I'm here for John Warfield.
Is that your witness or something?
Yes. Yes, there was an offer, but I had not had contact with Ms. Clark, but there was an offer extended.
No, I just asked you, was that your witness?
Oh, yes, that is the complaining victim on that case, Your Honor.
You need to speak with her?
Yeah, I could just speak with her briefly.
Okay, well, hang tight when the prosecutor gets a moment. I'll put him in a meeting room with you. Okay, Ms. Clark? No problem. Okay, on the record in the matter of the people of the state of Michigan versus Gabriel Pruden, file number 23-02370. Appearance, please.
Jeff Bradowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Gabriel Pruden.
Okay, Mr. Pruden, we reset this matter for pretrial today because there was a supplemental discovery request that had not yet been satisfied in October. How did you get that request?
We have not yet received the body worn camera.
I do have an update on that request, Your Honor.
Yes.
I checked our file this morning. I had not received, I know our discovery department had sent that out. I had not received any update from our discovery department, so I checked our file. According to our discovery department, they did receive a response from Ingham County Animal Control. There is no body worn camera on this this matter, Your Honor.
Okay. That understanding, how do you want to proceed?
With that understanding, Your Honor, we would ask for an adjournment. This is a case that involves two co-defendants that are represented by two different counsels. Our hope is that we could find some sort of a global resolution, perhaps with one more adjournment, given the fact that we now know the limitations of the evidence. I can work with Mr. Yang and the prosecutor, and we can come back to the court with a resolution.
Okay, on the record in the matter of the people of the state of Michigan versus Jordan Purvis, file number 23-02371. Can I have your appearance for the record? Mr. Yang.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Jordan Purvis. We're both joining via Zoom.
Okay, and so this matter was the co-defendant matter, and my understanding is that there, on this matter, was a FOIA request that was denied by Ingham County Animal Control. Was that for body worn camera, Mr. Yang? Or
Yes,
something
Your Honor.
else?
So body worn camera
Okay.
was one of them. There was an additional request, but I don't think that's dispositive of this issue. It was a copy of the complaint to Ingham County Animal Control, but as counsel pointed out earlier, we will try to figure out a resolution now that we understand there's no body worn camera.
Okay, sounds good. So I'm gonna reset both these matters for pretrial.
Do December 4th at 10.
December 4th at 10 work for you, Mr. Yang?
Yes, Your Honor, that does work for me.
Okay, December 4th at 10 is the date that we are rescheduling these matters for. Any additional matters for the record on both files?
Nothing from the people, Your Honor.
Nothing for Mr. Pruden, Your Honor.
Nothing further on behalf of Mr. Purvis.
Thank you. You're both all set. We'll get you a copy of your notice, Mr. Pruden, since you're in person. Okay, on the record in the matter of the people of the state of Michigan versus John David Warfield, file number 23-03187, counsel appearance.
Jeff Bradowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of John David Warfield.
Today was the date and time set for pre-trial on one count of domestic violence. Was there an offer?
There was an initial offer, Your Honor, and that would be for Mr. Warfield to plead to an added count 2 of disorderly jostling. However, that was without having any contact with the victim, as the victim has appeared here today. I would ask the court for a brief adjournment so that I may consult with the victim, because that may change the offer that we are extending at this time, Your Honor.
The offer was already extended?
Yes, it was extended on Friday evening.
You've already communicated that offer
Yes.
to your client?
I have communicated that offer.
Did he accept the offer?
Yes, he did.
I know you know basic contracts. You can't withdraw the offer because you didn't get contact with your. You can explain why the offer is what it is now, but you can't withdraw it if he wants to accept it. He still wants to accept the offer?
Yes, he does.
Mr. Warfield, the offer was for the people to amend the, or of this to an added count of disorderly jostling. You want to accept that offer?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, this matter, sir, you have the right to proceed to a trial and you have the right to jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, Your Honor.
You have the right to require the prosecution to prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt at a jury trial. You have the right to remain silent at that jury trial and not have silence be used to prove or imply that you're guilty. You have the right to confront and cross-examine in court any other witnesses the prosecution intends to call. You have the right to call your own witnesses at trial or present evidence that you believe further defense to the charge. Do you have any questions about those rights so far?
No.
You willing to give up each of those rights today in order to enter a guilty plea to disorderly jostling?
Yes, Your Honor.
Anybody threatening you to get you to waive your rights and plead guilty to the added count of disorderly jostling?
Yes.
Who threatened you?
Say again? Oh, no, I'm
My
sorry. No, someone coughed and I thought I heard you say something else, but no, no one threatened me.
Okay, my
I
question says,
apologize.
anybody threatening you? I just
Oh,
wanted to
no,
make
no.
sure Mr. Lee didn't put you in a headlock and tell you you got to take this plea.
Oh, no, I apologize. I misheard you.
Okay, very good. And then is anybody promising you anything to get you to want to waive your rights and plead guilty?
No.
Are you currently on probation or on parole?
No.
You understand that a guilty plea could result in a conviction that you may need to report to your employer?
Yes, but I currently do not have one.
Well, you may need to put this conviction on a future job application. Do you understand that?
Yes.
You also can end up with a conviction that might impact where you can travel or immigration status. You understand that?
Yes, Your Honor.
As to the added count 2 of disorderly jostling, how are you pleading?
Guilty.
Anybody, I'm sorry, you're pleading guilty because you believe you're guilty, correct?
Yes.
Actual basis.
Thank you, Your Honor. Mr. Warfield, on or about October 20th, 2023, were you at the location of 2910 Beau Jardin, apartment 302?
Yes.
And that is in the city of Lansing, county of Ingham, state of Michigan, correct?
Correct.
And while you were there, you had an encounter, that is to say, an argument with Meredith Clark, correct?
Correct.
And this argument spilled out into the hallway?
Yes.
Okay. And there was some grabbing, pushing, shoving type activity?
Yes.
No further questions.
Any questions from you, Mr. Barlow?
Nothing, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea if find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing, and that is on November 13th at 9. I'm sorry, today's November 13th. It's January 9th at 9 a.m. Okay.
Is that in person or will that be Zoom as well? Do you know?
You can appear via Zoom for your sentencing. However, you do need to report to our probation department in person within the next 48 hours. So you'll have until 11 o'clock on Wednesday to report to probation, okay?
Okay. Is that the number that would be on the blue paper that I got?
Yeah, that's the number, but you got to report in person.
Oh, yes, of course.
Okay, and they'll get you set up for the pre-sentence screening and interview so that I can know how to sentence you best, okay?
Okay.
Do you have any questions?
No.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing for the defense. Thank you.
Thank you, you're all set, sir.
Thank you.
You're welcome, Mr. Shaw. That's okay. For the record in the matter of the people of the state of Michigan versus Matthew Torres. I have file number 23-00818, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Matthew Torres.
Ten o'clock final pre-trial, that's just funny to me. Okay, let's see. You don't have final pre-trial selected. Right. Okay, today was the date that was reset for final pre-trial because you had a final pre-trial, Mr. Torres, and you failed to appear. I have a note from the magistrate at your arraignment. It said that you didn't come because you couldn't handle another court hearing.
Dealing with the front of the court for several years, and I just got sick of going to court. And the reason why I'm here today is filing a parenting time complaint with my caseworker.
You can't handle another court date, but you have pending matter. That's what you're here for today, a disturbing. You have a pending criminal matter.
Yeah.
What do you mean you can't handle another court date? You have to take care of your business, don't you?
Yes.
Yeah, you don't get to skip out because you can't handle another court date. You need to appear and take care of your business. Stop tying up court time while you sit at home and hide from it, okay? Do you understand that? Is that a yes?
Yes.
Okay, council appearance?
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Matthew Torres.
Okay, does this matter continue to trial?
I would leave that to the defense, Your Honor. The people have made 2 offers in this matter. If you would like me to put those on the record, I can.
Yes, please.
Okay. The initial offer was for Mr. Torres to plead as charged to count 1 of, I believe it's disturbing the peace, with a Killebrew agreement for fines and costs. After speaking with the complaining witness at the last date we were set for trial, who are their employees of friend of the court, they provided what they would like to see happen. So I extended a second possible offer to the defense, which would be for Mr. Torres to plead to the charge on a delayed sentence, Your Honor. And the condition of that would be that Mr. Torres attend a anger management program, and at the completion of that, the anger management program, with proof of completion, the people would then dismiss count 1.
You communicated those offers to your client?
No, Your Honor. The second offer is an offer that I just learned of this morning and would like to spend maybe 5 minutes talking with my client about which, or if either of those offers he was to accept.
And I would just, for the record, I would apologize to the court for that. Up until recently, Ms. Donnelly from the Public Defender's Office was handling this matter. I relayed that offer to her and then to Mr. Lee this morning as he's taking over the case.
Okay, Mr. Torres can have a seat, and when we're available for you to speak to him, you can do that.
Okay.
You have another matter that's already here.
Yes, Mr. King.
Okay, on the record of the matter, the people of the state of Michigan versus Nicholas King, file numbers 20-03531 and 20-03532. Council appearances.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Nicholas King.
Okay, and Mr. King, today's the date set in both of these matters for pre-trials on unlicensed dog. We have dog licenses now, or do we need time to bring them into compliance?
At this time, Your Honor, after conversations with Mr. Lee, Mr. Lee informed me that he learned this morning that Mr. King apparently no longer has the dogs. The dogs are now with his ex after they've split. And so the people would ask for, and I believe the defense would join me in asking for a brief adjournment so that we can just obtain proof that Mr. King no longer has the dogs, at which time the people would dismiss this for compliance.
December 4th at 10:30. Have any questions today?
Oh, Your Honor, would it help if we were to contact my children's mother so that she can confirm that I'm no longer in possession of the dog since the split?
That's up to the prosecutor. He's the one who's got to hear the evidence or see that evidence. I don't, okay?
Yes, ma'am.
So if that works for them, that works
Yep.
for me.
Yes, ma'am.
And then he'll make a motion to dismiss if that satisfies it, okay?
May we do that today?
Yeah,
Oh,
I have no
I'm sorry.
problem.
Yes, ma'am.
I have no problem with that, absolutely.
Yes, ma'am.
Okay, you can have a seat there, and then when he's available, he can step out to do that, okay?
Yes, ma'am.
Okay. Off the record on that matter. And Blair Betts is present via Zoom.
Yeah.
Okay, on the record in the matter of the people of the state of Michigan versus Blair Marie Betts, file number 23-02994, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Riley on behalf of Ms. Betts.
Today was the date and the time that was set for a pretrial and dog at large. How are we proceeding?
Yes, Your Honor, at this time, I have received an email from Mr. Raleigh providing a proof of compliance for his client, Ms. Betts, so the people would move to dismiss this for compliance.
Motion to dismiss is granted. You're all set, ma'am.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus David Cheney, file number 23-01459, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Riley on behalf of Mr. Cheney.
Oh, is he in custody?
He is, yes.
Downstairs?
I put him on.
Interesting. Well, he's not here, so we'll reset it.
November 27th at 8.
November 27th at 8. On the record in the matter of the people of the state of Michigan versus Michael DeRose, file number J038155. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Nybert serving on behalf of Mr. DeRose. Mr. DeRose is just there, and I think he just walked away from the camera for a second, Your Honor. There he is, Mr. DeRose.
Mr. DeRose, can you hear me?
Yes.
Thank you. Today was the date and the time that was set for a motion to set aside conviction. I have a motion for conviction, date of conviction being April 29, 2004. Mr. Rylitz, did your office receive a copy of that?
Yes, Your Honor, I believe we did. Ms. Nybert did forward or did send to myself, I believe, all of the necessary documentation after we were here last time.
Okay, very good. And we do now have a response from the Office of the Attorney General. The Attorney General's office indicates that they believe the defendant may be eligible to have this conviction set aside under Michigan Compiled Law 780.621. And after the court holds a hearing to determine if he meets the statutory requirements, order could be entered granting that. So, Ms. Nightberg, did you want to address the court, or does Mr. DeRose want to address the court as to what he's been doing since the time of his conviction?
I will, Your Honor. I have interviewed Mr. DeRose. Mr. DeRose is a mechanic through and through. He spent his career doing seats for GM and Oldsmobile, but unfortunately he has been an alcoholic that entire time. He started drinking when he was 13, when his dad died, and then started smoking. He was up to 3 packs a day. Michael didn't have much guidance and therefore didn't finish high school either, Your Honor. Michael went on to have 1 daughter and 2 grandchildren who he loves deeply at this time. He moved to Mount Pleasant in 2008 and 2009 when he met his girlfriend to get away from this trouble that he was in. He's been sober now since 2000 and no longer smokes at all. He feels so much better inside and out now that he's clean and sober and has all the toxins out of his body. Michael lends his time to his girlfriend's father and helps him mow the lawns and takes care of his rental property as requested by him. Michael loves to work on cars and works on his garden. He tries to grow corn, beans, and peas and potatoes if his dog Ozzy doesn't dig them up before he can. And Your Honor, he tries his best to be the best person that he can be. He tries to give his time to anyone in the community that allows him to do that. He tries to be a friend to the neighbors. He tries to be try to do things for other individuals that ask him to do so. So we're asking that he has this expungement for that time, Your Honor. He would like to get a job to help him with having extra cash to help him do some side stuff that he would like to do with his free time.
Thank you. And your client did not wish to address the court itself today?
Mr. DeRose, have I said enough for you?
You're muted, sir.
I don't think so. I think he said it was fine, Your Honor.
Okay, very good. I reviewed the application and his prior criminal history, and then hearing the information, ma'am, that you provided on his behalf. I want to applaud him for turning his life around and even addressing those issues or use of substances in his life that aren't even illegal, but just making efforts to try to get his pathway more clear. I think that it's appropriate and according to the law provided to set aside this conviction. And I find it to be consistent with the public welfare. So I'll sign and date it for today. Congratulations to you, Mr. DeRose. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, thank you, Your Honor. Thank you for this time.
Thank you. You're all set.
Thank you, Mr. DeRose. Good luck. See you later.
Back on the record in the matter of the people of the state of Michigan versus Matthew Torres. Mr. Lee, how does your client want to proceed?
Your Honor, my client is going to accept the offer from the prosecuting attorney to plead guilty with a Killebrew to no upfront jail and fines and costs only.
He gave the offer, you said Killebrew of fines and costs. Is it now Killebrew of no upfront jail and fines and costs? That what you're saying?
The Killebrew was to just fines and costs, Your Honor.
Okay. You want to accept that offer, sir?
Excuse me.
You want to accept the offer to plead guilty to disturbing the peace?
Yes, I do.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, I have an advice of rights and plea information sheet. It has today's date on it, and that's your signature, sir.
Yes, it is.
You read this document?
Yes.
You understand the rights listed here?
Yes.
You want to give up each of these rights today? So that means you're going to give up your right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
That's correct.
And you want to waive having them prove you guilty so that you can enter a guilty plea?
Yes, correct.
That means you're giving up your right to remain silent at a trial and not have silence be used against you. You're giving up your right to have the prosecutor prove each element of the charge of disturbing the peace beyond a reasonable doubt at your trial. You're giving up the right to cross-examine any other witnesses that they were going to call. You're giving up the right to call your own witnesses or present evidence at your trial that you believe further a defense to the charge being brought against you. Do you understand that?
Yes, I do.
Is anybody threatening you to get you to waive your rights and enter a guilty plea?
No.
Any promises being made to you in exchange for a guilty plea?
No.
You understand a guilty plea could result in a conviction that you may need to report to your employer.
Yes, I do.
A guilty plea could also result in a conviction that may have impact on travel or immigration status you may be seeking.
Yes.
Are you currently on probation or on parole?
No, I'm not.
Okay. And there's a killable agreement. That's an agreement between you and the prosecutor. I'm not a party to that. You understand that?
Yes.
So that means that when I decide what I'm going to sentence you, if it's different from what you all agreed, I'd let you have an opportunity to withdraw your plea, okay?
Yes.
As to disturbing the peace, how are you pleading? Are you pleading guilty because you believe you're guilty?
Yes.
Factual basis, counsel.
Mr. Torres. On or about October 24th, 2022, were you at 313 West Kalamazoo Street in Lansing, Michigan?
Yes, I was.
And that's in the county of Hingham, the state of Michigan, correct?
Yes, correct.
Okay. And did you, while there, throw a chair or otherwise disturb the peace?
Yes, I did.
Thank you. No further questions.
Any questions from you, Mr. Barrett?
Nothing from the people, Your Honor.
What is satisfied with the factual basis? I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. Is there an objection to immediate sentencing?
No objection, Your Honor.
No objection.
You can address the court.
Thank you. Your Honor, Mr. Torres comes before the court contrite, humble, accepting responsibility for his actions. He asks the court's forgiveness and begs the court to understand the incredible stresses and pressures that he has been under in dealing in front of the court. Certainly everybody can understand how emotional dealing with ex-spouses and children and custody issues can be. But he does admit that the way he handled it was not appropriate and asks the court to consider his cooperation in sentencing.
Did you find one with the statement himself?
You want to make a statement?
I just apologize to the court. It's done. Been pretty emotional. Trying to see myself. I'm probably not gonna see him till 16. I just went down there to file a page time complaint for the down page time that escalated to an argument. And then I just had it off the bus.
Just recently I was talking to one of my friends who's a family court judge, and I was expressing my sentiment about how emotional family court issues are and how the issues escalate there far quicker than what we deal with when we deal with criminal matters. So I understand the gravity, what was at stake. Now you're talking about the life or spending time with your child, and how those things could trigger emotions that you probably were not at the time equipped to handle. In hindsight, I'm sure you wish you handled it differently. I think you benefit from resources and classes if necessary that could help you navigate the system better. You have rights as it relates to being a parent. I recognize you made a statement just now in your allocution or statements to the court that you don't believe you'll see until you're 18. The rules for family law is what's in the best interest of the child. And so you still have rights as it relates to that, whether those rights mean that you can see your child with supervision or without, and how often you will see your child. That's something for the court to make a determination, and you should not give up your quest and your fight to see your child just because of this hindrance, okay? Don't let this stop that. Let this be a lesson to you. This is not the way to address it. And I don't know if you have an attorney in your other matters. That's for you to decide as to how you want to address your other matters. But those friend of the court issues can be challenging. They can be triggering. You need to do something to make sure that you're still presenting yourself both in courtroom settings and outside of courtroom settings to be a person that can provide stability and support for your son. Sons need their fathers, but he needs to see that you're a good example. And you carrying on and flipping out in the middle of the friend of court doesn't fare well in your favor if what you're trying to show them is that you need to be able to spend time with your child. Do you understand that, sir? Yeah. I think that at this point, you suffered enough loss and consequence of being hauled in and out of the court for this matter since the 13th or the 30th of March. And then obviously the consequences that this could have placed on your custody battle. With that being said, I think the Killer Brewer fines and costs is appropriate. Your fine is $100. And can you make payment? We'll get you over to the criminal traffic window. You can make payment today, and this will resolve this matter. And you won't have any more court matters on this one, but you need to go to all your court dates. You can't blow off your court date because of how stressful it may be. It doesn't help you. It doesn't help you to go to court on a family matter and get upset and start throwing furniture around. You see that now, sir?
Yeah, I understand.
Okay. Good luck to you. Now I have to.
Really quickly, Your Honor. Just,
yes,
we don't need to go on people, so we were just gonna step out briefly.
Okay, sounds
to make
good.
that phone call, then we can
Thank you.
readdress that matter.
Back on Flores. Back on the record in the matter of the people of the state of Michigan versus Angelo Garza. I'm sorry, who was this man? Not Angelo Garza. I gave you the files back. Versus Nicholas King. Did you get what you needed, or do you still need?
Yes, Your Honor. The people are satisfied after making the phone call with Mr. King and Mr. Lee present. And so that Mr. King no longer has the dogs in his possession, so the people are moved to dismiss for compliance.
Motion to dismiss on both files. Granted, you're all set.
Thank you. It was a pleasure this morning.
Thank you.
Thank you all. You guys look good.
Have a good one.
Take care.
And Garza built it. That's all we have for the morning.